Welcome to episode 83 on the Law Report. Today's episode is going to be a very short episode, and it follows on the previous episode where I dealt with the basis of plea. And in that episode, Newton hearing came up, and I thought that I need to explain what is a Newton hearing and the full procedure involved in a Newton hearing. So I'll be back shortly to discuss Newton hearings in criminal proceedings. But before I do, my usual disclaimer: this is not legal advice, should not be considered as such. For legal advice, please contact an attorney of your choice. Welcome back. A Newton hearing occurs when a defendant has pleaded guilty to the offense charged or to an alternative offense, but on the basis of a different version of facts from that of the prosecution, and the court has concluded that the factual differences would make a material difference to the sentence to be imposed on the person who has pleaded guilty. A Newton hearing operates as a mini trial called a trial of issues. During the Newton hearing, evidence is called by both parties, and a judge sitting without a jury or a magistrate decide the basis on which sentence will be passed. The burden of proof lies with the prosecution to satisfy the court beyond reasonable doubt that their version of events is correct. The name Newton hearing stems from a 1983 case of the Queen and Newton, in which a defendant admitted burglary but claimed that his wife had given consent. The Court of Appeal ruled that in such cases there were three ways of resolving the issue. It may be possible to obtain an answer from a jury by directing them to consider whether there is the necessary intent for a specific offense, or whether a lesser offense which does not require intent is made out. If that is not possible, then either A, evidence be heard from both sides and a conclusion reached on the matter which was the root of the problem, or B, no evidence is heard but submissions are analyzed, and where a substantial doubt still persists, the benefit of that doubt be given to the defendant. An unsuccessful Newton hearing from a defendant's point of view can have an unfortunate consequences on the defendant. Not only will that defendant be sentenced on facts that are more serious or on the Crown's version, but the defendant will lose any credit for having argued the point in issue unsuccessfully. So for a defendant, there is a balancing risk and benefit to be considered. As the Newton hearing takes time, resources, and, no doubt, testimony. If unsuccessful, it will reduce any sentencing credit that might otherwise have been attributed to the defendant. This aspect of the sentencing process and the defendant's loss of credit in a Newton hearing has been criticized by legal commentators and practitioners on the basis that the same risk or no risk at all exists for the prosecution, and therefore the Newton hearing could have unrealistic or could allow unrealistic bullying or foolhardy prosecutors to force defendants to choose between having a Newton hearing and playing it safe. In other words, it could force a defendant who fears that he or she may lose credit if they argue the point in issue unsuccessfully, that they may decide, instead of taking the risk of losing the point and losing credit at sentencing, that they may play it safe and plead guilty, accepting the Crown's version, even if they believe that the Crown's version is incorrect. So in this sense, a Newton hearing is seen as being stacked heavily against a defendant who must prove the entirety of their concern in order not to suffer from the consequences of failure to prove the issue in dispute. The practice, in my view, operates as a disincentive for a defendant to opt for a Newton hearing. Many defense advocates or defense lawyers, including yours truly, avoid Newton hearing because unless they are resolved entirely in the defendant's favor, some credit is likely to be lost, and it may be that any gains made by the Newton hearing are consumed or swallowed up or was outweighed by the credit reduction. Therefore, some practitioners, criminal practitioners that is, feel that there is no incentive to a defendant to embark on a Newton hearing, because even if they are partly successful, they gain no credit from it. I hope that this explanation is uncomplicated and straightforward. Here is where I will leave this episode for today. In my next episode, by request from a viewer, I think I will dive into hearsay evidence in the Turks and Caicos Islands, look at hearsay evidence in England and Wales, and probably in the United States, but probably at the federal level, since different states may have different laws regarding hearsay evidence. But until that episode, if you like this video, please share, comment, and give it a thumbs up. And I will see you very shortly in episode 84. Bye for now. Cheers.
Thank you for watching another video on the law report. Please like, share, comment, and most of all, thank you for taking the time out to watch this video. See you in another episode.